Ms. Lengame and Mr. Davis.
Thank you, Mr. Toby.
May it please you, Justices, Lavan Becker, Victoria Law, together with Mr. Criminal, the matter of solidarity, this is Mr. District, case number 365/2005.
Thank you, Mr. Becker.
25.
May it please the court, my ladies, appear together with my little friend, Ms. Kosana, for the first respondent, the Minister of Trade and Competition.
Thank you, Mr. Nalani.
As a part.
As the court pleases TJ Bukala, I appear together with Ramapali and Kurani for the second response.
Thank you.
As it pleases the court justices, Senate is materials and initials as said. I appear in the Latin Rose letter together with my sister Advocate Kate Mafano and Kate Harte. In the solidarity letter, I appear together with my sister Advocate Chabalala.
Thank you. Mr. Matibesi.
Matelese.
Matibesi.
Yes.
May it please you, my ladies, together with my little friends, Mr. Sangazana and Ms. Kruger, I appear for Advocates for Transformation in both applications.
Mr. Mutau.
Madam.
Any appearance for the sixth respondent?
May it please you, my lady, I appear together with my learned friend, Ms. Lekwane and Minomonde, on behalf of the sixth respondent, Basadi Bamla.
Thank you.
The name is Sello.
Sello. Thank you.
SPWLO.
As the court pleases me, I'm Moses Kakame, together with my learned colleague, Ms. Mbofu. We appear for the Black Conveyancers Association, the seventh respondent.
Is it Mr.
Kakame.
Skakama?
As it gives you, my lady, I appear for the eighth respondent, the Black Lawyers Association, together with my learned colleagues, Mr. Ramali, Mr. Morris, Ms. Makanya, and Ms. Kubeka in both matters, as it pleases you.
Mr. Deering.
As it pleases you.
Yes. Any appearance on behalf of the ninth respondent?
Thank you, my ladies. As it please the court, I am Advocate Sigalala.
Sigalala.
I appear together with my learned friend, Ms. Casey Butelezi, and we're led by Norman Aronsa, for the ninth respondent, the General Counsel of Bar.
Where is Mr. Orange?
Mr. Aronsa will be joining us a little bit later, and will be joining the matter from tomorrow.
Thank you. 11th respondent? 11. Oh, 10.
My lady, I appear on behalf of the 10th respondent, together with my colleagues, Advocates Brown and Advocate Brown. My surname is Ipser, I-P-S-E-R.
Yes, thank you. I-P-S-E-R. Thank you. 11th respondent?
My lady, I understand that the Pan-African Bar Association has withdrawn their opposition to this matter.
12th respondent?
May it please my ladies, Ms. Mangani, together with my learned friend, we are led by Advocate Valerie Mere SC, who's unavailable for the duration of the hearing.
Unavailable.
Unavailable, my ladies, for due to other reasons. I'll be available.
Ms. Mangani?
Yes, my ladies.
So you lead.
It seems so, my ladies.
Thank you.
May it please.
And then Amicus Curiae?
Yes, my ladies. I am Kate Hoffmeyer. I appear for the Amicus Curiae, the Johannesburg Society of Advocates, together with my learned friends, Ms. Naidu and Ms. Malinga. We are also joined by Mr. McConaughey, but he's not in court today. He's in another matter here this week, but he will join us later.
Thank you. So, Mr. Bong, we're back to you.
I think you still need to call the other matter, the solidarity matter.
Oh.
There are two matters before you.
Yes.
You've heard appearances for the first application. There's the solidarity matter.
In the solidarity matter, you've called on
I
behalf
have.
of the applicant.
Indeed.
Respondents in the solidarity matter?
They overlap, my lady, but yes.
No, that's what I was told, but thank you, Mr. Bong.
Justices, may I start off by first expressing gratitude, and I'm pretty certain I speak for all my colleagues, for the patience shown this morning. There have been quite a few discussions. We haven't reached any resolution. There will be certain further things that happen during the course of the day. Whether it gets anywhere or not, we're not sure. But what we would ask you to do at this stage is to scan the matter to tomorrow, and if you want to start a little earlier on account of the time lost, we don't have a problem. That's in your discretion, 9:30 or 10.
Why?
Oh, to start the hearing. So in other words, the default position would be for the hearing to commence, unless we come back to you with something different.
Yes, but the reason for the matter standing down until tomorrow?
Oh, because, my lady, your ladyship, let me place on record. We engaged in the discussions yesterday, so there was quite a lot of time spent during the course of yesterday. Crucial time, certainly for myself and my learned friend, Mr. Ngugaitoibi, for purpose of the presentation, was eaten up for the course of the day. So we would want to use this afternoon to do what we would otherwise have done yesterday afternoon. And I'm being quite open. It's a question of we made a judgment call to enter into the discussions, which took longer than it would have taken. If it had gotten somewhere, and if it still gets somewhere, that would have been worth it. But if it doesn't, we still believe that the time available will be sufficient to conclude the matter. What you may want to do is extend by half an hour each morning and each afternoon.
What we will do is commence tomorrow morning at 10.
Yes.
And see then how
How
the day
it goes.
progresses. And then we can start deciding on sitting long hours.
That's the first issue. The second issue is the following. There was an original notification for a virtual hearing. You received a notification. I asked my attorneys, and I must say those who are here were as taken aback as I was. So there's no concern from the first applicant's perspective of a virtual hearing. The position, as I understand it at the moment, is the three applicants are in favor of a virtual hearing.
Three?
The first, second, and third.
Four.
The four applicants are in favor of a virtual hearing. From my discussions with my colleagues for the first, second, and third respondents, the first and third is fine with the virtual hearing. The second has no problem with the virtual hearing. In other words, it's amenable to that. I've spoken to some of my other colleagues, but I'd rather them place their own position. It does seem as if most of the parties do want a virtual hearing. Once you've heard all of the parties, to the extent that I need to make submissions to you on why it should be a virtual hearing, I'll do so. So perhaps you may invite the other parties just to give their indication.
This is the only issue that's outstanding.
That's on which a ruling is required now.
Thank you. Let's see then, Mr. Toby.
My lady, we agree with the stand down to tomorrow. There is discussions going on. They may get somewhere, they may not, but at the very least, we want to give them a chance. We also support a virtual hearing for the reasons that Mr. Baum has advanced. Thank you, madam.
Thank you. Yes, Mr. Baker.
Really, yes, a virtual hearing is also preferable for solidarity, and the reasons that were obvious. We don't have an issue there. It's not an issue of matter standing down. We don't have an objection in principle. The legal teams for the applicants have engaged in the course of last week in order to curtail certain portions of our argument, not to overlap.
It's always advisable.
So we sit in the position that we have naturally prepared for our portion of that argument, and if the matter can't be resolved by the applicants, then they will be talking to the respondents. In the matter of Norton Rose or the Naces, the now court, then the matter should simply proceed tomorrow, and we should follow the sequence as we have actually agreed.
So shall we call you the fifth applicant? Let's just refer to solidarity.
Yes, my lady. There are the applications overlap to a large extent, but there are certain issues naturally. But we don't have an issue being called the fifth applicant. I think it's going to be easier to then actually, whilst the matter flow.
Well, we'll still refer to you as solidarity, just to make sure that
it's a separate case.
It reflects.
Yes.
Thank you, Mr. Nalani.
I confirm what my learned friends, Mr. Barnes and Krakow, have said.
Thank you. And then it is Mr. Bukava. Mr. Bukava.
We are agreeable to the stand down to tomorrow morning. However, the preferred method of hearing my instructions are that it should be in person,
An open court.
no, in open court.
And you are quite satisfied that there's enough space for everyone to unpack and pack and so forth?
That's a judgment call to be made by my
No,
client.
no, no.
Reach out.
It is for the parties to
Yes.
indicate to this court, because what we want is for the parties, the main players, so to be called. That will include up until the third respondent. Those are the main players. To be comfortable in presenting the matter. In other words, to have enough space, because it is an extremely important matter. But you as the second respondent is comfortable utilizing what you have to properly present your case.
Yes, and then reach out to instructions, I'll do what the client say I must do.
Oh, I hear you. Mr. Matibesi.
Thank you, Justices. On behalf of the third respondent, we do not have a problem with the letter standing down tomorrow. We also do not have a problem with the letter.
Thank you. Mr. Motau.
Thank you, Justices. There is no difficulty to have the matter stand down. The preferred position in accordance with my instructions are for the matter to proceed in open court.
I see you also emphasize your instruction.
Now, Justices, you would have picked up from the matter that initially there was an indication that the matter was going to proceed virtually.
For the reasons that were provided.
Yes. And then subsequently, that position was altered, which is why we're here today. And as a result, people have traveled from faraway places to come and attend the hearing. I mean, for reasons that I don't need to delve into.
Well, at the end of the hearing, people need to travel back. So if they travel back this afternoon or at the end of the hearing, they still need to travel back.
Yes, no, I mean, the point I was trying to make is not really about the traveling back. It is the reasons for which people have decided to attend in person, given the nature of the issues that lie for determination in the matter. Those are those assumptions.
Mrs. Kakana?
Mr. Court, please. Two things. I confirm the discussions that will happen for the matter to stand down until tomorrow. The preference of my client for the matter is to be held in open court.
Thank you, Mr. Silo. Oh, Miss Silo. It was Mrs. Kakana, Miss Silo.
Indeed, right, my lady. They just both happen to share an S. For the sixth respondent, we have no issue with the stand down to tomorrow morning. That is supported. My client's preferred position would be for the matter to be heard in open court due to the nature of the issues, and we believe the importance of the issues and public interest in the matter. That would be the first preference. We, however, are in the court's hands. I just needed to put our preference on that.
Why is there a perception that the public will not be able to follow the proceedings if it's held virtually?
My client's position is that not all members of the public are able to log in on the link and therefore follow the proceedings. However, if it is an open court and it's broadcast on national TV, it becomes accessible to a far larger number of the population. Thank you.
Mr. Skakana, we've dealt with you, Mr. Deary.
My instructions are that this, firstly, that the matter should be heard in open court, but we do not have an objection to the matter standing down until tomorrow. Our only concern is that whether the matter would be completed in time there's been correspondence exchange between the parties. I don't need to go with it, where these concerns have been raised and how the argument should be meant by the parties should be fitted in or to be presented in order to finish by Friday 5 o'clock. But to the extent that you would recall also from a practice note that the applicants, all 5 of them, needed a day and a half or day in a court to argue the matter. So when we argue, we just want them to keep that in mind and curtail their arguments.
Mr. Dearings, I hear you, but you have realized, well, that is our position when we read the papers. The issues overlap a lot.
Yes.
So we hope that each and every council that has an opportunity to address us will not repeat everything over and over and over. So that was our hope, but we...
That's our hope too, madam. Yes, please.
Thank you, then. It's Miss Sikhe Lala.
Thank you. We have no principal objection in relation to the stand down to tomorrow. My ladies, I don't hold any specific instructions in respect of the format, so we're in the course.
Thank you. Ms. Ipser.
Thank you, my lady. My lady, equally, we have no objection to the stand down. My instructions are, and the view of my client is that this matter should be heard in open court. It is a matter of great significance, and we believe that open court and with benefit of television would be better.
We'll reach more.
We will reach more of our constituent members.
Yes, and then Mankhane, Miss
My ladies, we do not object to the stand down to allow the parties to talk and see if they can meet each other halfway for a settlement, if that is possible. Secondly, we would appreciate the matter being held in open court, but we are in the consent. And to answer my lady's question as to people can travel back, for example, there are colleagues that came from the Western Cape and the Eastern Cape to attend this matter, and those colleagues are acting pro bono. So the issue of travel is not as simple as traveling back to Joburg. For others, it will not be possible because they've already booked, and because the directives require that the matter be held virtually. So if that can be taken into account when the court decides whether it's held virtually or in open court.
Thank you, Ms. Hofmeyer.
Thank you, my ladies. In keeping with the Johannesburg Society of Advocates' position as an amicus in this matter, we don't weigh in on the merits or demerits of these aspects. We're in the court's hands. We're here to be of assistance to the court this week.
Thank you. Yes, thank you. Having discussed the matter with my sisters, the matter will proceed in open court.
As the court, please.
We will then the matter will then stand down until tomorrow 10 o'clock. I hope that all counsel in all of representing all of the respondents have taken to heart what I've indicated of not repeating the same arguments over and over again. And we should be able to finish in 4 days. Thank you, Court adjourned.
So please, when he's done,
You want to get rid of the right shape.
we're not